Welcome back to On Record PR. This week, we're revisiting a previously recorded conversation. In this replay, Gina Rubel goes on record with Phil Goldberg, Office Managing Partner at Shook, Hardy & Bacon, to explore the power of a compelling narrative in litigation and why strategic messaging can make all the difference in high-stakes cases. Whether you're tuning into this episode for the very first time or giving it a fresh listen, we think this episode still resonates today. We'll see you next week for a new recording.
Today, I'm going on record with Phil Goldberg, Office Managing Partner of Shook, Hardy & Bacon's Washington, D.C. office. Phil is co-chair of the firm's public policy practice group as well. He has more than 25 years of experience on high-stakes and high-profile liability-related public policy, public affairs, and public relations issues. And let me tell you, he's got a lot to share. His practice involves counseling businesses and their trade associations on some of today's most cutting-edge liability issues. Phil, I am so honored to have you here. Welcome.
Thanks, Gina. So happy to be here and glad we've gotten to know each other, pretty well, and looking forward to this conversation for sure.
I am too. This is exciting because there's such an intersection between what I do and what you do, right?
Absolutely.
My company does public relations, high profile litigation, but you're doing it at the law firm. And so I'm curious, what do you see right now as some of the biggest change in the way that litigation is waged in the United States, and why does it matter?
It's a great question. There has been a lot more of litigating outside the courtroom and trying to use, whether it's public relations, use government relations in order to leverage what happens inside a courtroom. And so the interdisciplinary nature of litigation and public relations really come together in a lot of high profile cases. And a lot of it has to do with, how cutting edge the liability theories are, trying to make sure that, from the plaintiff side, if they can get out there and define an issue, a defendant, even if they have a legitimate defense, may not even want to take the case to trial. So a lot of times these cases can be won or lost outside of the courtroom and in the public relations sphere. And one of the things that we're seeing that really is, I think, fundamentally changing litigation in this country is the use of what is called third-party litigation funding. So you have these hedge funds and these investors that are investing money into developing litigations against large companies. And so they will fund, all the TV, lawsuit advertising we see at 2:00 in the morning. That's all being funded by these outside financiers. They're marketing litigation the way companies might market a product. And so they're trying to get people to sign up for the litigation, again, much in the way that public relations people help market products for their clients. They're doing that for litigation. And it really is changing everything about mass tort litigation, because a lot of times the people who respond to these ads or who and click through or do whatever, they're not really injured or they never really use the product, but a lawsuit gets filed in their name anyway. And so there's a lot of kind of figuring out how to understand, with big litigations, is this like cotton candy where you put a little water on it, it all disappears? Or is this something that's more real where the people actually have injuries for which, the company might be responsible for? So it's changing a lot of the underlying assumptions about how the law works and about how, and how the public interacts with big litigations.
So it's interesting that you mentioned that. And I think it's important for some of our listeners to understand that there's a difference between public relations and advertising and marketing. So, for example, the advertising side is that pay to play.
Right.
The public relations is how you communicate a message. Generally, it's strategy and it's how it gets perceived by the public audiences, but it's not necessarily play to pay. So what I think I hear you saying is in that litigation funding space, there's a lot of pay to play. How do you combat that in the court of public opinion, in other words, PR, as a practicing attorney when you're dealing with high stakes, high profile litigation?
Well, a lot of it is trying to make sure that you have, even within the company, that you have the legal department, the communications department, and the government affairs department all talking together when you have these kinds of high profile litigations. And you have the consultants, like you have the outside lawyers, you've got the outside PR firms who specialize in litigation public relations, and you have even some of the government affairs people all coordinated and rowing in the same direction, because a lot of times the plaintiff lawyers are coming at these companies in these multidisciplinary ways, and the companies have to respond through their multidisciplinary departments. And if you look at it as just a legal issue and not a public affairs or government relations issue, you're missing the boat, and you might be harmed, not effectively combating some of the pressures that are facing the company in these other areas. And if you look at it as just a public relations issue, that may not be good for legal. So you have to make sure that everybody's talking together and working to defeat some of the messages that are coming at you in the litigation.
One of the things I found most refreshing when you and I were introduced is that we think alike. And you might have seen me smile when you said rowing in the same direction. And I have been using that analogy for so long that it just made me smile, because I'm like, we just think alike. What I think is important, and I'd like some of our viewers to understand from your perspective, is the intersection of the court of law and the court of public opinion, and why it's so important for us to all play together nicely. In other words, litigators and PR professionals and the government and public affairs people, why it's so important for us to be communicating together and collaborating early on.
Well, I'm old enough to remember there was a book called Men Are From Mars and Women Are From Venus, if I remember the name of the book correctly. And in some ways, the legal and lawyers are from Mars and PR are from Venus, and we're not talking the same language. And so once you break that down and help understand, so in the court of law, for example, you have a right to remain silent, right? Everyone knows that from watching Law and Order. If you remain silent in PR, you're assumed to be guilty, right? That you don't have anything to say to defend yourself. You can go through a lot of what lawyers would say, like, we're not going to defend this case in the media, and the PR people are like, we don't want you to defend your case in the media, but we have to talk about the underlying issue. We have to talk about what's going on here, what your consumers care about, what your business partners care about. It's not litigating your defenses, right? And so once you can break that down and you can help the lawyers and the PR people understand that they're on the same side and they're trying to achieve the same goals, it's just they're doing it in two different environments, then you can get, to use the expression we were talking about, you can get everyone rowing in the same direction. But so many times you have people with these preconceived notions, whether it's in legal or in PR, that are just antithetical to each other, but they don't realize they're really not antithetical to each other. They have to realize they're working in different arenas, they're working in different ballparks, and what works in one ballpark is not going to work in the other one. You just have to understand that. So
I'm curious, if you were working on high-profile litigation, and let's say you didn't have all the seasoned people in your law firm like you do who understand PR and the court of public opinion, what would you look for in an outside consultant or agency to make sure that they can speak the same language?
So, I used to work in public relations. I used to do litigation PR before I joined the law firm. This was 20-something years ago. And so I was in that position, and having lawyers on the other side, with the client, trying to make sure that we were understanding each other. And so I do like to see lawyers in the PR firms. I think that's very helpful. I'm not saying that you can't do a good job at litigation PR if you're not a lawyer. You certainly can. But if you have somebody who understands some basic concepts of how liability and legal systems work, and when you're putting together public statements, what just won't fly, right? So I remember one time I had, even as I was at the firm, as a lawyer, but a client of the firm came to me and said, we're getting these statements from these PR firms and they're just not right. Can you take a look at them? And it happened to be a friend of mine who was one of the PR firms, one of the PR people working on this. And she wrote a great statement, but there were literally like 4 or 5 words in there that I just tweaked because I know what lawyers will be sensitive to and what they'll kind of freak out about. And I sent it back. I'm like, oh my God, this is perfect. This is great. I'm like, actually, it was great before too. It's just, she just didn't know how to avoid some little hot button issues or words that maybe like that seemingly creates a standard, right? Like health and safety is our number one priority, or our top priority. is different from saying health and safety is one of our highest priorities, right? Mm-hmm. Because if whatever you say in the court of, when that statement gets put up on a bulletin board in trial, and they're going to say, you said this was your number one priority, but over here you have a memo saying, let's look at the finances of this versus that decision, blah, blah. Was that your number one priority in that? So if you just don't use language like that, but say, we put a lot of emphasis on, safety, or whatever. It's one of our core, ethos of this company is health and safety. Whatever it is you do, you say it, but don't say it in a way that you're gonna regret it later, because that'll be used against you in how you actually said it, when you're conveying the same thing either way.
That is great advice. Phil, we're going to pause here for a message from our sponsor.
This episode is brought to you by Furia Rubel Communications, a public relations and marketing agency serving law firms and businesses worldwide. With an expert team positioned throughout the U.S. and supported by an international faculty, Furia Rubel enhances our clients' brands through integrated communications by providing expert guidance in crisis management and high-profile litigation, protecting brand and reputation, and supporting internal marketing teams. To learn more, visit furiarubel.com.
Welcome back, everyone. And if you're just joining us, I'm on record with Phil Goldberg, the office managing partner of Shook, Hardy & Bacon in Washington, D.C. And we're talking about the intersection of PR with public policy practice in litigation and high-profile matters. It's such a great conversation. And Phil has worked in PR, and I've worked in litigation and vice versa. So we're two peas in a pod, as you will. So what are some of the things that you've seen change in the way we handle litigation today? Is there anything that's different than you would have seen 10, 20 years ago?
Yeah, I think there's an understanding among some of among some lawyers, but some, I don't want to say better lawyers, but in my mind, maybe they are, who appreciate that when you're writing a brief and you're arguing a case in court, that it's not just about some dry legal analysis. It's about trying to connect with the judge, trying to connect with the jury, try to connect with the people who are paying attention to this litigation in a way that's meaningful to them, so that they feel good about whatever outcome it is that you're asking them to reach. And so, and I remember, this probably about 15 years ago, I was talking with a client, and they asked me about their briefing in the case. I said, well, what do you think? And I said, well, to be honest, if you pick up the plaintiff's brief, the first 2 pages read like a press release. They're bringing you into their side. They're connecting with you. They're pulling your heartstrings. They don't get to the legal issues until page 3 or 4, if they ever do, right? But they're trying to persuade you by understanding their story. You pick up the defendant's brief, or I said your brief, and it says, didn't do it, not so, wasn't us, and it kind of just goes through the rest of it. I said, you have a really compelling story to tell about why you didn't do what you're being accused of. You have a really compelling story to tell about what this company is about. And nowhere does that appear at all in the first page or 2 pages of the brief. And I said, but when a reporter picks up the plaintiff's brief and the reporter picks up your brief, they're not going to get any sense of this. All they're going to hear is this compelling story on one side and didn't do it on the other, and they're going to write a story that way. And I will tell you, I'm working with a team of lawyers on an appeal, and we brought, the PR people in, maybe not at the beginning, but about, the initial draft of the brief was done. We sent it to the litigation PR team that we're working with. This is a high profile case. And we asked for their thoughts about how to strengthen the first, the introduction really is what we care about. And I don't think that would have happened 15, 20 years ago. I think there's a greater understanding now that you have to tell a compelling story, even if you're just talking to a judge, but particularly if you're talking to appellate courts, if you're talking to the public.
If it's getting filed and it's not, under seal, all courts. And, so it's so interesting you say that, because I can go back 20 years and say that I was handling a high-profile Ketam case. I was on the PR side, hired by the law firm representing the client, and said exactly that. And the law firm's like, pleadings aren't meant for the media. And it was so frustrating. I mean, when I say high profile, this was an AmLaw 100 firm then. And the idea was pleadings are just pleadings. And they never tell you that in law school, that pleadings are accessible to the media. They can get them and will get them. I've seen where reporters know that we represent a certain client, and they will literally within hours of a pleading being filed, reach out and say, hey, I saw that your client filed X. Do you think they would be willing to a conversation about Y? And you would think you should be surprised. That doesn't surprise us. We're prepared for that in advance.
Right.
I can tell you 90% of high profile litigators don't prepare in advance and do not use their pleadings as a tool to convince or sway the court of public opinion.
Right.
And they're accessible, and there's nothing in Rule 3.6 that says they're not accessible. Right. And I don't want to get into an ethics conversation.
Right.
That's for the lawyers listening. We can talk about that. Send us messages, text us, call us, email us. We'll answer that. But to know that pleadings are just important to journalists in particular. And we've often said to, especially in defense matters, while we can't speak on that matter publicly because of the rules of ethics, we will be filing our pleadings and the answer will be in there.
Right.
We say it much more eloquently.
But I think that's right. If you can provide the media with some good sound bites or snippets in your opening introduction to a brief, then you don't have to comment on it afterwards. And you've carefully crafted those words and it's gone through the vetting process. And it's so much easier than talking about the case. Now, of course, in my world, the plaintiff lawyers are often very happy to talk about a case, often will leak documents and do all the things that, a lot of aggressive plaintiff lawyers will do. And that's fine. And we expect that. We understand that that's going to happen from time to time. But it's how, from the defendant side, we respond. There seemed to be more in the past the notion that the sin of commission is worse than the sin of omission, right? So if we say something and it goes south, then that's on us. But if we don't say anything, we ignore the reporter and there's a bad story, then we just get to blame the reporter and blame, the plaintiff's lawyer and blame everybody else. And it's not our fault, right? But I think today there's a great understanding that if we don't manage the litigation stories and it's bad, there is also a sin on us as well.
So what's your take on people saying no comment?
Well, I mean, again, no comment, I think, means that you come across as sounding like you have something to hide. It comes across as sounding like you're not confident in your position. I think there are very constructive ways to talk about a case and talk about, your company or yourself in a way that is effectively not commenting on the litigation, but it's providing a comment that the people who you care about, again, you care about when there's a story being written about your litigation, there are people you care about that are reading that story. They're going to learn about you and learn about this issue and this dispute based on what they read. Do you want them reading only the other side's point of view, potentially getting the reporter getting things wrong? Or do you want them to read things that, even if it's 80% the plaintiff lawyer's view and some things are wrong, but at least you can convey that message about who you are as a company, why this issue is important to you and to others in your situation. I think that if you can do that, you're not commenting. So it's technically, if you want to say it's a no comment, but it's a comment that can go into the story that can inform people that you care about.
I agree 100%. We, whenever possible, and I have had many arguments with clients, saying no comment, it's like, it makes me picture the person running out of the courtroom with a briefcase, hiding their face, it's
the hand in the camera.
Right. Like it's perceived as guilt.
Right.
And so on either side, so just don't do it. So before we end, I'd love you to tell us about any interesting case that you might be involved in or one that you were involved in, of course, that's non-confidential, that most people wouldn't know about and why it's important.
That's a good question. So, I mean, with my policy practice, we often get involved in kind of these cutting edge legal issues as they're playing out in the courtroom. And sometimes there are people who care about an issue, a political issue, but then they turn it into litigation. And so we end up dealing with that. One of the ones which I find to be interesting that I've gotten to work on, and strangely over 20 years, probably know more about animal damages and animal injury cases, because there's a group of people that want to inject emotion-based damages in, so that owners can get their emotional harm damages for their pets, often even more so than they can get for their own children, or certainly more than they can get for their human best friend. And while that sounds really interesting to a lot of pet owners like myself, the last thing that's good for our pets is to drive up the cost of pet care, drive up the cost of pet products and services so that owners can get liability money out of that system, right? Think about the human healthcare system, where liability drives a lot of decision making. If the veterinary care system was like that, that wouldn't be good for our pets. And the pets don't get the money, if as owners we get it for our emotional harm, but if it means that pets don't get care because veterinary care and all that becomes more expensive because now they got to pay out these large awards, then pets are going to suffer. And so it's kind of like these PR issues we deal with all the time, where something may sound good at first, it may sound interesting at first, but then when you truly understand it, you come to the opposite conclusion. And so I think that's one of the issues I've been working on. Actually, I filed 2 briefs on it in the last month. So it's certainly an interesting issue these days, but that's one of the things that comes to mind.
Well, I definitely at some point want to learn more about that. I don't think you know this, but our daughter is in vet school at the University of Pennsylvania. And
congratulations. That's awesome.
It is. We're so proud of her and our son, who's in his senior year of college. But one of the things that we've learned is that the veterinary community has one of the highest rates of suicide. And I've seen how abusive pet owners can be to the people in veterinary practice, and how, there's so much blame placed on the care providers, and yet very little on the owners taking responsibility. It's really fascinating because hearing you talk about that and seeing it firsthand as the mother of a care provider in the pet world, it is a huge issue.
It's intensely emotional.
And I'll tell you, you're doing more than just protecting pet owners by caring about the cost of the care. You're also doing work that's in the best interest of the care providers. So I want to say thank you for that.
Well.
And a lot of people don't know that it has one of the highest rates of suicide in any industry.
It's also one of the most well-respected professions, right? I mean, so when you look at they do these surveys of, how high esteem you have for certain, how much esteem you have for certain professions. The veterinary profession is always, high at the top because they care a lot about the pets. That's why they're doing it, right? I mean, and unfortunately, pets can't tell you what's wrong. And so it is very different than human healthcare in that regard, and having to try to figure it out, having to understand the budget of the owners. I mean, the veterinarians that we work with often tell us that they've put pets down over procedures that would cost like $500-$600 because the owners say, we can't afford that, but we don't want our pet to suffer. So, and it's an older dog or whatever it is. And so they end up, and you're like, that can't be the right answer either. So it's a very difficult and emotional situation in a lot of these cases.
Well, I think we're going to have a whole nother conversation on that because we're out of time.
On Record PR is produced by Jennifer Simpson Carr and Matt Henderson, with support from the team at Furia Rubel Communications. Visit www.onrecordpr.com for resources and more information.